Everyone to the 2025 Labor Law Update. Today is sponsored by Monterey County Works. My name is Anna Manzano, and I'm the digital media and event strategist here at the California Employers Association. Before we get into today's training, I have just a couple details to go over with you. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during today's training. You're already doing so in the chat. Love that. Keep it up. If you have any questions about the content, you can enter those into the Q&A box at any time. If you are on a desktop computer, you'll see it along the bottom, a little button that says Q&A. That'll just help us keep it organized, and Mary knows one place to look. So if you end up with a question in the chat, I might just ask you to copy it over to the Q&A. Cool, easy peasy. Handouts for this training were sent out in yesterday's reminder email, but what I'm gonna do is drop that file into the chat. So soon you'll see the file name with a little PDF icon pop up. If you still need the handouts, you can just click it and it'll download locally to your drive. And if you have any questions or any trouble accessing that, just ping me in the chat and I'll make sure to get it to you one way or another. The recording, we always get questions about how to access the playback. So because Monterey so generously sponsored today, I will be sending them the recording, and once that is available for your viewing, they will reach out to everyone with instructions on how to do so. So hang tight on that. And then last but not least, we do have a survey. So it's 5 questions. It generally takes less than a minute to complete, but the feedback that you share with us at the end of today's training, we then share with our partners over at Monterey, and we collectively just make sure we are meeting and hopefully exceeding your expectations with trainings like this, as well as our entire suite of resources. So you'll see a QR code at the end. There'll also be a browser window that pops up. You can choose your own adventure there. So now I want to, again, thank Monterey County Works for sponsoring today. Today we're joined by a few people, but I'm gonna call in Laura Kirshner, our business services specialist, to share more about the resources available to employers like you.
Well, thank you so much, Anna. We are so delighted to be here, as always, sponsoring this event. It's such a great opportunity, and here we have quite a number of people on today. I just wanted to take a minute to welcome everyone and to really ask you to reach out to us here at Monterey County Works. If you are a business that is struggling, that needs some assistance, we would just love to help you. We do have a number of different opportunities for you. We have an upcoming job fair on January 29th. You may register on our website, montereycountyworks.com. We can help incentivize you with some of our on-the-job training opportunities where we reimburse you at 50% of an individual's wage. You can learn more on our website about all the different things that we offer, montereycountyworks.com. You can register for our job fairs there or our customized recruitments. There's just a whole bunch of different ways that we can help our local businesses. We also have a human resources hotline that might be of some use to you. We can make referrals for you for individuals for different jobs. There's all different kinds of things for you. MontereyCountyWorks.com. I'm Laura. I'm here every day of the week. 831-796-3341. Love to chat with you and learn how we can assist you. Thank you so much and enjoy the seminar today. These folks do a great job.
Awesome. Thank you, Laura, Corey, and Linda for joining us live today. And as they mentioned, they'll be dropping their contact info into the chat box shortly. Also, you do have copies of these slides in your PDF, which I did just also drop in the chat if you didn't access that through email. So make sure you take advantage of those resources available to employers like yourself. Okay, so I would love to introduce our trainer today. We are joined by our Senior HR Director, Mary Bradford. So you are in excellent hands, and I'm going to kick it over to her.
Great. Thank you so much, Anna. And thank you, everyone from Monterey County Works. We always enjoy doing webinars with you. And as you saw on the prior slide, there are some more webinars coming up. So we encourage everyone to join us for any webinars that will be helpful for you as you try to manage the HR function, which is the ever-moving, ever-changing target of being a business owner in California. So you do have all those dates and those QR codes in your slide. And of course, you can give us a call or send an email to us at the hotline. We'll be happy to help you out with that. All right, well, let me start with a really quick introduction to CEA. If you're not familiar with who we are the voices that are behind the HR hotline. That's the California Employers Association. We have an entire team of HR directors who are available to help you Monday through Friday, 8 to 5 on that hotline number. So please, anytime you do have questions, give us a ring. It is a wonderful benefit that Monterey County is providing to you. We encourage you to use it. Anytime we can try to make your life a little easier, which is our goal at CEA, is to try to bring you peace of mind by helping out with those HR questions, those HR issues that we have. We're going to be talking about labor law update for today, but if you have any follow-up questions after today's training, of course, give us a call, or questions about anything. We help with leave of absence issues, wage and hour issues, all of those things that you're dealing with every single day. A real quick disclaimer here before we get started is CEA is not a law firm. So when you call us, you are not going to be receiving legal advice. So please keep that in mind. What we're giving you is information, we're giving you resources, we're giving you options, but all of those decisions that you make for your employees are up to you. And so we're not giving you a legal opinion. If you ever do need to consult an attorney, we recommend that you do so, because sometimes issues come up where you do just need a little bit of extra help. We do have a list of partners on our website. I was going to point out on the slides, you will see our website, which is employers.org. We encourage you to visit that. We have newsletters, we have blogs, we have links to our partners that we'll talk about today. If you ever do need a little more assistance, I do encourage you to take a look at the website. We've got some good stuff out there. All right, well, we have a lot of information to cover together before 11 a.m. So let me kind of give you a quick overview of what we're going to be talking about, and then we're going to jump right into it. So we are going to talk about wage and hour issues, because again, I know you're dealing with those every day. There's been a change to minimum wage in statewide, but then there's been changes all over the state. So if you have multiple locations, you'll need to worry about that. We're going to talk a little bit about PAGA and independent contractors, which is ever changing and evolving. Then there have been some big changes when it comes to employee rights, protected classes, audience or captive audience meetings. We'll talk about that. Then we're going to spend a little bit of time talking about leave of absence issues and some benefit changes that you'll need to consider for 2025, specifically some expansions. And that's really what a lot you'll see today. A lot of leaves or laws have been expanded or changed or clarified. So we'll talk about those when it comes to crime victims specifically, paid family leave, as well as CalSavers. And then I'm going to wrap it up a little bit talking about workplace violence prevention plan that you might have heard about. That went into effect last year, but that is still active and something you need to be looking out for. And heat illness, which I know many of you have to deal with that in your industries based on our attendees today. So we will talk about that as well. And again, as a reminder, anytime as I'm going through today, feel free to put your questions into that Q&A box. And then at the end of each section, I'll take a look and see if there's any questions I can answer or any clarification that you might need on what we were talking about. All right, so let's jump into wage and hour. The number one thing to remember, and one of the biggest mistakes, I just got off the phone with someone this morning who was incorrectly paying somebody, is wage and hour and minimum wage in California. So as a reminder, minimum wage in California did go up January 1st to $16.50 per hour. So that is the minimum that an employee must make in California. And the reason we always pay attention to what the minimum wage is because that affects what the exempt salary requirement is. Keep in mind, in California, all employees automatically default to being a non-exempt or an hourly employee. So that's why we want to make sure we're always paying that $16.50. So as a non-exempt employee, that means they get breaks, they get their meal periods, they're paid for overtime, all of those non-exempt rules. Now, the non-exempt salary affects the exempt salary. How they determine the exempt salary is they take the state minimum wage, multiply it by 2, multiply it by 2080, which is the number of work hours in a year, and that's how they come up with that exempt salary. So $68,640 is what all of your exempt or salaried employees must be making annually. Now, you might be looking at this and thinking, I'm not paying my exempt employees enough, or maybe I've misclassified them because I just wanted to avoid overtime. That happens. So what we would encourage you to do is take a look at changing anyone that you feel should not be classified as exempt, or perhaps you just simply can't pay that salary level, and transition them to a non-exempt hourly employee. And we've actually put together kind of a little tips and tricks guide for you, because so many businesses have had to do that because the cost of having an employee classified as exempt has gone up so much. So remember, you're always safer keeping your employee as a non-exempt hourly. So take a look at that cheat sheet, or of course, give us a call at the hotline. We'll be happy to talk with you about some strategies, because you do have to kind of retrain and recoach your employees on clocking in and out and taking those rest breaks and those meal breaks and overtime. Now, the other thing to keep in mind is that we have more than 40 separate local ordinances that have a different minimum wage or a higher minimum wage in California. So we've actually put together another cheat sheet for you, because it's very difficult to keep all of these straight. Several of them are in the Bay Area, as well as Southern California. So you do want to make sure that you are always paying the minimum wage where your employees are working. So if you are based somewhere where it's the state minimum wage, but you have an employee who, for example, works in Emeryville, which has a much higher minimum wage, you need to make sure that that individual is being paid the minimum wage where they are physically working. So that's why it's a good idea to keep an eye on those minimum wages. They usually go up January 1st. Some do go up July 1st, but we do have a couple that go up April 1st. So that's why you want to make sure that you're always keeping an eye on those minimum wage requirements in California. Now, the good news is when it comes to determining your exempt employee salary, that does not vary based on where they live. So the state minimum requirement for exempt employees stays the same, except for a couple of industries we'll talk about here in just a moment. So you don't have to worry, though, that you need to change an exempt employee salary because they work in Emeryville, for example, or they're in Los Angeles. So you can just follow that state requirement when it comes to exempt salaries in most situations. But of course, there's always it depends, because when we're talking about fast food, this is one of those industries where you do have to pay a higher salary for your exempt employees. So you might remember hearing about this last year. This fast food minimum wage went into effect April 1st of last year, and that brought all employees who work at basically a fast food chain, if they have 60 or more locations nationally, they would fall under this. All of those individuals needed to be bumped up to $20 an hour. And again, that was as of April 1st, 2024, so last year. We have not heard what change they are planning for this year. We do anticipate there will be another increase. It's possible it will be April 1st. Perhaps it will be over the summer. We haven't heard officially, so stay tuned for that if you do fall under this category. But the thing to really pay attention to here, if you are in this fast food industry, is it does affect the exempt employee salary because they have a higher hourly rate. They did change it to say that exempt employees who are in the fast food industry have to be making $83,200 a year. As I mentioned earlier, I just got off the phone with someone who works at a pizza chain that we work with, and they have been paying employees the state exempt requirement as opposed to the fast food worker exempt salary requirement. So you really do have to pay attention to these things. One of the things she said to me was that, well, I just can't believe my payroll company didn't tell me. And the payroll company said, well, it's your responsibility to know how much you're paying your employees, which is perhaps a little harsh, but it is actually true. So you do want to make sure, don't rely on your payroll companies to catch payroll errors or to catch that you're not paying your exempt employees properly. You want to make sure you're really keeping an eye and doing a wage and hour audit to be compliant with that. Another change where it comes to a different minimum wage is for healthcare. If you're in the healthcare industry, I know you've been dealing with this a lot. The idea is that eventually healthcare workers will all be up to at least $25 an hour. There have been a couple of delays with this, and then it finally went into effect October 16th, and it increased the minimum wage for individuals from $18 to $23 an hour, depending on your industry, depending on what group you are in. We are anticipating another increase as of June 1st. So this is if you're in the healthcare world, this is where you want to work closely with your CPA, with your bookkeeper, with your attorney, whoever you're working with, to make sure that you are paying the appropriate minimum wage for those employees. It also gets a little tricky when we get to our exempt or our salaried employees. They need to be paid at least 1.5 times the healthcare minimum wage for the industry that they're in, or 2 times California's minimum wage, whichever is greater. So that's why if you're in the healthcare world, I know you've been dealing with this, but this is again another reminder, you need to audit this a couple of times a year. You need to keep an eye to make sure you're knowing when those increases are going into effect, and you're adjusting any of those salaries appropriately. Another thing to keep in mind when it comes to paying our employees is that we do need to reimburse our employees for mileage when they are traveling on behalf of the business. So the IRS has come out with their 2025 rate, which is 70 cents per mile. So it went up 3 cents from last year. So anytime that you tell an employee, I need you to get in your personal vehicle and I need you to drive to this customer location, or I need you to drive to our other facility, or I need you to run to the bank to go pick up or deposit and pick up cash for us, whatever it is, and your employee is using their personal vehicle, you do need to reimburse them for that mileage. We always recommend that you reimburse the IRS rate, again, which is 70 cents a mile, because if you pay that rate, that's the IRS saying, well, you're paying for gas, you're paying for insurance, you're paying for wear and tear on that vehicle. If you pay less than that, the employee could have an argument that you need to pay them back for whatever happens, if they get a flat tire or if they get a dent on their car or something like that. So that's why we always advise, make sure you're paying that IRS rate. The other thing to keep in mind is if your non-exempt employees are traveling for you under your direction, you need to pay them for that drive time. So that is all compensable time. So you're paying them for their time as well as that mileage. Another thing I want to talk about here as we start to kind of wrap up our wage and hour portion is something called PAGA. You might have heard of this before. That stands for the Private Attorneys General Act. And what that is basically a law that attorneys have used to sue employers for labor code violations. It's been around for a couple of decades, but really in the last couple of years, it got a little out of hand, got a little out of control. And so a couple of groups came around. The legislature said, gosh, we need to make some changes to this. There was talk about there being a proposition on the ballot. But what ended up happening is a couple of Assembly bills and Senate bills were signed into law as of July 1st of last year, which greatly changed PAGA. And this is a good thing for businesses. What they did is they said, we're going to make some changes, but employers have some responsibilities here. And I'll talk about that here in just a second. The thing to keep in mind, though, is that this has been in effect since June 19th of last year. So if you've received a PAGA claim, I'm sure you're probably working with an attorney, which is what we would recommend, but you do have a little bit of relief for these PAGA claims that were received last summer and moving forward. So here's what you need to do as an employer. They've given you these opportunities to take these, what they're calling reasonable steps, to show that you are trying to comply with wage and hour laws. So what does a reasonable step mean? Well, that means you should be doing a payroll audit, just like I was mentioning before. When it comes to minimum wage, if you're in a different industry, you really want to be keeping your eye on wage and hour issues. And so you should be auditing your systems. That means you're taking a look at how are people clocking in and out? Are they doing that properly? Are they getting their meal breaks? Are they getting a minimum 30 minutes for their meal breaks? Are they being paid overtime when overtime is due to them? So you want to do an audit, and then when you find errors, you want to make sure you correct them as quickly as possible. That's your big trick there. You also want to make sure that you have properly written policies. So we always recommend everybody has an employee handbook. One of the things you should have in an employee handbook is your timekeeping policy. Also a policy that says we don't allow off the clock work, and all of those good things that should go into your wage and hour policies for your non-exempt employees. The other thing you want to make sure you do is train your supervisors. A lot of times supervisors don't really know what the guidelines are. You want to make sure they are up to date on that. If you have multiple locations, you want to make sure that everybody is on the same page and doing everything consistently, so you can make sure that you are implementing all of your wage and hour policies across your business. Now, the good news is we have a couple of tools for you that CEA has put together because we've worked with so many members on this. We have a wage and hour audit package that you can purchase. It's on our CEA store, so you can go to employers.org, CEA store, and check that out. And contained within that is a PowerPoint that you can also purchase for your supervisors that will actually train your supervisors on wage and hour issues. And if you need a refresher, it's a wonderful tool. You can customize it for your group. Makes it very easy to do all these things. So recommend take a look at that if wage and hour has been an issue for you. I know it's always a headache, but do make sure you're staying on top of that, because PAGA lawsuits, which often turn into class actions, are very, very expensive, and we don't want anyone to have to deal with that. Last couple of things here is we're talking about paying employees. This is actually in regards to independent contractors. So if you ever work with independent contractors, you know that's gone under quite a big change in the past couple of years. And again, this is another clarification that they've come out with this year, talking about single independent contractors, sometimes known as freelance workers. So if you are working with an individual and they are performing a service for you that is more than $250, they are saying now that you are required to have a written contract with that individual. I think most of you were probably doing this before. If not, make sure you're doing it now. And that contract has a couple of requirements. You need to have, the name and mailing address for each party, the list of what this person is going to be doing for you, how much you're going to be paying them, when they're expected to be paid, anything to do with rights and responsibilities for that action or the work that they're doing for you. You're also not allowed, and that's one of the reasons they want you to put together a contract, is you can't say that, hey, I know we agreed that I was going to pay you $500, but if you want to get paid on time, I'm only going to pay you $400. Those kind of things you are not allowed to do. And of course, hopefully you've never did that in the past. But now having this contract where it clarifies the payment responsibilities will hopefully alleviate a lot of that. Also, it can help you in that it can grant some more intellectual property rights to you as the individual. So if you hire someone to take pictures, I know we've got a couple of landscapers on with us. So if you hire someone to do photography out at a site, a before and after, perhaps put together a promotional video for you, you can clarify that that property can be yours at the end of the project and just spell those things out in your contract. So this is some of the services that this applies to. So again, as I mentioned, videographer, photographer, for example, maybe you're hiring someone to do some graphic design for you. Maybe you're using appraisers, those kind of things. So if you fall into one of these categories or you're working with someone that falls into one of these categories, again, do make sure that you are putting together that written contract. This is an opportunity where it's really good to work with an attorney, work with counsel to put together that agreement. California has some special rules, of course, that you need to follow. So if you just pull an agreement off the internet, it may not be your safest option, and you always want to make sure you've got an attorney in your back pocket if you need it when it comes to those things. All right, a couple of to-dos here for you. Make sure that you're following those minimum wages, adjust accordingly. Always keep an eye, again, on exempt salaries as well. You also want to make sure you're providing your employees with a wage theft notice when you are changing their salary. That is Form 2810.5, DLSE 2810.5. That's one of those forms you give out when you hire an individual. But if you have a pay change and if it's not going to be reflected on their pay stub within 7 days, you want to make sure that you're giving them that new wage theft notice. We just recommend it as a best practice anyway. Make sure you're doing those reasonable steps for PAGA. So do your wage and hour audit, keep an eye on everything, make sure you're being compliant. And of course, review those independent contractor agreements to make sure you're staying up to date on those and you have everything in writing that you should have in writing to be compliant. All right, so let's jump on over to employees' rights and protections. So as we know, California is always working on protecting employee rights, making sure that harassment and discrimination is not occurring, and making sure employees have the freedom to do things that they might need to do. So let's jump into some changes with the EEOC. Now, this is actually at the federal level, EEOC, Equal Employment Opportunity Commission. They have, after 25 quick years, put out some updated guidance when it comes to harassment. Now, keep in mind, in California, it has been much more clarified and restrictive when it comes to harassment in the past couple of years. So this is really kind of the EEOC catching up to what we have been doing. And remember, when California has a stricter law or a more protective law for employees, we always follow that. But now the feds in California are a little more aligned, which is nice. So we can have some more consistent guidance on these issues. So the EEOC came out with 77 different examples where they're talking about what really qualifies as harassment. So they talked about not asking inappropriate intrusive questions, denying access to bathrooms for people, misgendering people, remote work environments were covered in this as well. And then they also talked about something called intersectional harassment. And this is just the idea that there can be more than one protected category where somebody is being harassed. So it could be based on race as well as age, for example. Now, this is something that has been around for a while, this intersectional idea, but it was really just more clearly defined. California's talked about it as well, but they also hadn't really defined it. So FEHA, which is the Fair Employment Housing Act, this is California's Civil Rights Department, they also helped identify and define this idea of intersectionality, which means, again, we can't discriminate or harass against somebody for one or more or a combination of protected classes. What this means, though, for you is that you're going to need to make sure that you have updated your handbook with this language. So if you have an EEO policy, you'll need to add language regarding intersectionality, harassment and prevention policy, etc. If you do not have an employee handbook, or if your handbook is more than, say, 23 days old, it's probably outdated because we have all of these new changes that we're talking about today. So CEA actually has a sample employee handbook that is a DIY tool that you can purchase and put together for yourself for 2025. Or if you would like CEA to assist you with that, we certainly can. Give us a call on the hotline and we can talk about your options with putting together a customized handbook for you. But again, recommend you have a handbook where you talk about your wage and hour policies as well as your harassment prevention policies, which is required in California. So make sure you're staying up to date on those. So let's talk a little bit about hiring employees and a new change when it comes to driver's license requirements. So very often employers were in the habit of just in every single job, they would say driver's license is required. Well, the state doesn't want you to do that anymore unless it is truly required for that position. So if you as an employer really expect driving to be a function of that job and taking other forms of transportation just isn't feasible. So for example, taking an Uber doesn't make sense. It's too expensive to take an Uber. Then you need to make sure that you are not saying a driver's license is required in your job postings. So for example, if you have a receptionist and you need that front office person to go to the bank once a week or a couple of times a month, or maybe that person needs to run out to Starbucks to bring in treats on Friday, if that person could walk to the bank or take an Uber to the bank, or perhaps just have delivery of those food items, whatever it is, if they don't really have to have a driver's license, then you want to make sure you're not requiring them to have that driver's license, as opposed to if you have a salesperson, or if you're a company like CEA, where we go out to member locations everywhere. So I'm based in the Sacramento area, but I've certainly come down to beautiful Monterey several times. It wouldn't make sense for me to take a bus or take an Uber. That would be so much more expensive than me just driving. So all of the HR advisors were required to have a driver's license, but you do want to make sure that it really does apply to that job. So take a look at each of your job descriptions, take a look at job postings, make sure that any of those requirements, and specifically having a driver's license, really match up to what you require for that position. Another change we've had when it comes to employee rights are something called captive audience meetings. So what this law is saying is that you as an employer can't require your employees to come to a captive audience meeting if you're discussing religious issues, political matters, including labor organizations or labor organizing unions. Your employee is able to say to you, I'm not interested in attending that meeting. I won't be going to it. And you can't take adverse action against them. So this is just the idea that you can't say, all right, everybody, we're going to have a meeting at 2 o'clock and I want to talk about the prior and the current presidential administrations. So you're not allowed to do that. Employees are allowed to say, I'm not interested in that. I'm not comfortable with that. I won't be attending that. And that just means you can't take adverse action against them. Now, I will tell you, this is already going to the courts. There's already a lawsuit against this. We will also see if there are changes with the new administration. But for right now, you want to follow what the guidance is, which says to you as an employer, you can't require your employees to attend these captive audience meetings. Again, just if it's focusing on religious or political matters, including labor organizations at this time. Keep an eye on this. This is another reason to make sure you're checking in with our newsletters and you get our blog. You can sign up for those on our website, just so you can stay in the loop if there are any changes for this law or really anything else that we're talking about. We always like to let you know as soon as we can when there are changes. A couple of other reminders when it comes to labor law posters. You do want to make sure you have a 2025 California and federal all-in-one labor law poster. You can order one from us if you need one. There's also other resources, but we have them. We have them in English and Spanish. We can get those out to you very quickly if you do need those, because there are several updates. Specifically, there's a change to the whistleblower protections in California. There's a new poster. There's kind of just a basic statement or notice that they had put out before, but now there's an official poster for this law. Also, of course, minimum wage that we've all talked about. There are supplemental posters. If you're in the fast food and the healthcare industry, you want to make sure you get those up as well. Couple of changes to workers' comp, basically just clarifying that an employee has the right to consult with an attorney, some information on attorneys' fees, how those are paid. And then the Civil Rights Department very recently put out some changes when it comes to harassment discrimination that we talked about, family care leave, which we'll talk about here in just a minute, pregnancy disability. So a couple of little poster changes, but you do want to make sure you always have the most recent poster updated and posted. That's why it's often just easier to get one of those all-in-one posters, so you don't have a bunch of different postings just stapled up or put up on the wall, nailed up on the wall. So again, take a look at our website if you need that. We're always happy to help you with that. If you have questions on that, just call us as well. So a couple of to-dos when it comes to your employee rights. Make sure that you are also always training your employees on harassment prevention. Remember, they need to have that training at least every 2 years. Also, for new hires or individuals that are promoted into a supervisory role, that training needs to happen within 6 months of that event occurring. We always recommend just make it part of your new hire orientation process. It makes it a little easier to just check that off. But remember, your supervisors need to have 2 hours of training every 2 years. Your non-supervisor employees need to have 1 hour of training every 2 years. Also, you want to make sure you revise your handbook policies on the protected classes, everything that we talked about in regards to those changes at the EEOC as well as the state level. Review your job postings, application job descriptions for driver's license requirement. Always train your supervisors on all the things we're talking about, including those captive audience meetings, and get that new labor law poster up and posted on your wall. As a reminder, if OSHA ever comes into your workplace and you don't have all the appropriate posters posted, fines start at around $5,000. So it's worth buying a $30 or $40 poster, so you don't have to worry about those big fines. Okay, so let's start talking about some leave of absence issues and some benefits that you need to keep in mind here. So crime victims, this has been around for a while as well. So you might remember crime victims came out last year. So prior to January 1st of this year, all employers were required to give your employees time off if they ever served on jury duty, if they were ever subpoenaed as a witness, or if they needed to take time off, for example, if they were getting the temporary restraining order for the employee who's a victim of crime or their child. They could take vacation time, they could use paid sick leave when they were taking this time off. They were also always able to ask for a reasonable accommodation if they had concerns about safety at work, if they were a victim of domestic violence, some sort of assault or stalking. And of course, you as an employer, we always maintain confidentiality about this, as well as everything else, but very important to maintain confidentiality on this. And then this AB 2499, as it is known, didn't really change anything else. It didn't get rid of anything else. Again, this is kind of just an expansion and an increase on some of these protections that we had for our employees. But now we've got these big changes that we have that you're going to need to make sure you're reflecting in your policies and your practices as of January 1st. We have a new definition of what it means to be a victim and who is a victim. There's also reasonable accommodation. As I mentioned before, it was for the employee or their child. Now this can also include a family member, if a family member is a crime victim. And again, employees can use paid sick leave for all crime victim purposes. And there's going to be a new notice. So there will be a new notice that you need to provide to your employees upon hire. You will also need to provide this to them annually. Also, upon request, when an employee informs you that they have been a victim of crime or a family member has been a victim of crime, but we don't have this notice quite yet. So don't worry if you're looking through your paperwork thinking, where's I put that notice? It hasn't been created yet. So CRD, that's the Civil Rights Department, they will be putting this out by July 1st, and you will at that point be able to distribute it out to your employees. So again, keep an eye on our blog. We will certainly let you know, and we will send that out or post that as soon as that notice is available. But here are some of the changes that you need to know about now when it comes to these different expansions that they've had to this law. So this is, again, a victim is an individual against whom a qualifying act of violence has been committed. And here's the list on this slide. So again, domestic violence, sexual assault, stalking. This can be one of those things that, of course, we hope never happens to any of our employees, but if there's bodily injury, if somebody is threatening somebody else with the use of a firearm, if they're threatening to cause physical harm or injury or to kill someone, those can all be different forms of violence in the workplace that you might have to deal with, or your employees tell you that they're dealing with. So now we have this expansion of what a family member is. So it can be not only a child, but a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. The other thing is it can be a designated person. You've probably heard that term before. That has been in use for a couple of years, specifically when it came to CFRA, the California Family Rights Act, or paid sick leave, PSL, that an employee can have a designated person. So perhaps they don't have family members that are nearby, or they have a relationship with someone who's very close to them, or in loco parentis, someone who has stood in as a parent for an individual. So an employee can designate a person, and you as an employer can limit it to one designated person per year, but they can say, this is my designated person, and I need to take time off because they were a victim of crime. And so you would need to grant that time to them as well. Now, if you are a larger employer, if you have 25 or more employees, a couple of changes that, again, these are more expansions. So they might have they might need to take some time off if they need to provide or get some mental health services, if they need help with safety planning, perhaps they need to have assistance with providing care to a family member who is recovering from being a victim of crime. Now, you as an employer can limit this extra time to 12 weeks. This would run concurrently with CFRA, California Family Rights Act, as well as FEMLA, the Federal Family Medical Act, depending on your employer size. There are also some limitations, though. If the employee's family member is the victim, you can limit it to around 10 days or 5 days if it's used for relocation or school. So there's some different provisions there if you're a larger employer, but something to keep in mind if somebody is asking you for some extra time off. Another change when it comes to paid family leave, this is known as PFL, and there are changes into what you can require an employee to use before the leave started. In the past, you used to be able to say to an employee, you need to use 2 weeks of your vacation or your paid time off before paid family leave would begin from the state. You can no longer require that as of January 1st. So this is another handbook update you will need to make. Also, if you have specific forms regarding leave time off, make sure you update that as well to remove any language that says an employee must use 2 weeks of vacation before they're able to use paid family leave through the state. Another reminder here when it comes to CalSavers, as a reminder, if you aren't familiar with CalSavers, that is now coming down to the smallest employer if you have 1 or more employees as of December 31st of 2025. So at the very end of the year, if you do not offer a retirement plan, so if you don't have a designated retirement plan, a 401k, for example, and you have 1 or more employees, you need to make sure that you are registered with CalSavers. Now, this is what, if you haven't heard of this program before, this is a retirement program that the state has set up. You as the employer need to make sure that you register with CalSavers if you don't have a retirement plan, and you submit your employee information into CalSavers, and you would coordinate if that employee is interested in participating in the CalSavers programs. Employees can always opt out. It's not required that they participate, but they do need to be given the opportunity to participate in this program. There aren't any employer fees for you. You're just responsible for making sure that the employee is registered with the state and that they are participating if they want to. Again, it's totally up to them, totally voluntary. If you have a 401k, if you have a retirement plan that's available to your employees, you do not have to worry about CalSavers at all. But if you don't have a retirement plan, this is something you need to look into and make sure you are registered with the state by the end of the year. All right, a couple of things to wrap up our leave and benefits section. So make sure you update your crime victim, any of those other policies we talked about, depending on your employer size. Keep an eye out for that new notice that will be coming out by July 1st. And again, keep an eye on our blog or our newsletter. We'll make sure we announce that. Update any of your leave practices when it comes to an employee taking advantage of those paid family leave benefits from the state. Remember, you can't require them to use that 2 weeks of vacation before those kick in. And then, of course, register for CalSavers if you need to. And again, if you need help with your employee handbook or updating your policies, let us know. Give us a call at the hotline. I didn't mean to mention, I know you're seeing our other 800 number on a lot of these slides, but we do ask that you call in on that specific Monterey County number, just so we know where you're calling in from. All right, so our last section that we're going to talk about today are health and safety updates. I know it's been on our minds with everything that's going on in Southern California that they're having to deal with, and I know up here we are not immune to dealing with wildfires and our own natural disasters. So again, we're going to talk about safety. This is really just a snippet of a couple of things that have been going on. Again, if you have other questions about specific things, give us a call on the hotline. We'll be happy to talk about that with you. So when it comes to workplace violence, that is our WVPP. You might remember this from last year. This went into effect last year as well. Here's a quick overview. You as a business need to make sure that you have a workplace violence prevention plan in place and that you are reviewing that and updating it every single year. And you also need to make sure that you are training your employees on your workplace violence prevention plan. Now, this has been something that's been around for quite a while. In a couple of cities, specifically San Francisco, put this into place, but then it went statewide for California. If you you can incorporate this into your IIPP, your Injury Illness Prevention Plan, or it can be a standalone document. Do whatever works best for you, but make sure this is something that you are implementing. And if you haven't done this, give us a call on the hotline and we'll help you out with it. But you do want to make sure you've got that workplace violence prevention plan because there are some requirements that are already going to be coming up here for the new year. So you need to make sure that you annually review your plan. You also need to annually ask your employees for feedback. So you might have put your plan into place last year. July 1st is when it went into place, but maybe there have been some changes, or maybe there have been some incidents or questions brought up. So you should annually be asking your employees, are there any changes we should make to the plan? Are there changes we should make to the workplace? Are there things that you've thought about or you've been worried about? So just ask for their feedback. You do need to provide annual training, again, on the contents of that plan. Make sure you are doing some periodic hazard inspections where you're taking a look. Is everything safe with our security system, with our alarm system, with our doors? Do the appropriate people have keys or access to certain areas? So take a look at those. We do recommend that you have those safety meetings too. And again, this could be part of, maybe you have quarterly meetings with your staff or you have team huddles, something you could do a couple of times a year where you just kind of check in with everybody, see if they have any feedback, if they have any other suggestions for changes that you can make in the workplace to just make it be a little safer for everybody. So we do have a do-it-yourself workplace violence prevention plan package that you can get if this is something you haven't done, or maybe you think, oh, mine wasn't so great, I should probably update it. We put together a really nice DIY for you. So take a look at that if that's something you need, and that's available for you on our website as well. So then let's talk about indoor heat illness. This is something that went into effect last year, the second half of last year, so you may not have heard about this. You're probably already familiar with outdoor heat illness, and I know we have a lot of people that have outdoor industries. If you're in ag specifically, I know you deal with this a lot. But last year, the state said, you know what, we need an indoor heat illness standard as well. Now, I know for those of you that are on the coast, you normally have a little more reasonable temperatures, but for those of us that are inland or in the valley, we know how very toasty it gets over the summer. And so that's why the state said we need to have not only outdoor heat illness, but we need to have indoor heat illness protection as well. So what they said is if you have indoor work areas where the temperature reaches 82 degrees or higher when employees are present and they don't have AC, so kind of think about this as like warehouses, sheds, some kitchens, for example, then you need to take a look at having an indoor heat illness program. We do have a fact sheet for those of you that are CEA members. We have a lot of information on this. Just make sure you're logged in to our website so you can access all of it. But you do want to make sure that you've got a plan that's in writing and implemented if this applies to you. Some of the things that you need to include in that plan talking about how employees can access water. You want to make sure, of course, you have cool down areas for your employees, what you would do in an emergency, of course, making sure your managers and supervisors are trained, what people can do to climatize themselves to big weather changes or temperature changes when they're going from hot and cold. So of course, you're going to make sure you've got your plan for this. You're going to train your supervisor. There's also some additional high heat requirements when it goes over 87 degrees, or if it's over 82 degrees and maybe people are wearing some restrictive clothing. That can be somebody who's dealing outside with chemicals or certain treatments like that. Other hazards, they need to make sure that there's other protections in place for them as well. So again, if you have outdoor, you're probably already very familiar with this. Indoor mirrors it quite a bit, but do make sure if that is the situation you're dealing with, then you've got your plan in place. Another one, gosh, we're so close to being done with some of these requirements because February 3rd, 2025 is when this COVID-19 prevention non-emergency standard will actually end. So we're just a couple weeks away. Employers are still supposed to have a COVID prevention plan in place until that time. You've probably heard, or if you've read our blog, that the state is coming out with some, or they've come out with new guidelines and information regarding illnesses that might occur in the workplace that aren't just specifically COVID-19, since there's all sorts of respiratory things going on. I'm sure many of you in the business world have been dealing with people being absent because there's so many cold and flus going around right now. So there will be some general guidelines when it comes to safety in the workplace or illness in the workplace and how to deal with those. So keep checking the state website, and of course, keep checking in with us just to make sure that you're staying up to date on these things. There are still some record keeping requirements that will be in place. You want to hold on to any of those records you've kept regarding COVID through 2026. So I know it's tempting to shred everything, but don't do it quite yet. So hold on to those guidelines and those plans and any of your documentation until next year. If you need help with safety, certainly if you're a larger industry, workplace violence prevention plan, as well as heat illness plan, you might need a little more assistance. We have a couple of great partners that you can work with. We've got the Safety Center, we have the Safety Compliance Company, and they can help you with all those OSHA compliance, as well as the Shaw Law Group, which is one of our attorney partners. So if you need that help, absolutely let us know. And then let's talk about just a couple of things to remember as we start to go into 2025. I know it's already been quite a doozy of a year already, and we're just in the first month, but you want to make sure that you are staying up to date on your trainings. So that means, and remember, this starts when you're working with your employees upon hire or doing new hire orientation. This is when you're doing your harassment prevention training as part of that new hire orientation. You're also at that new hire orientation, and then throughout the year as appropriate, you're going to have your workplace violence prevention planning. You also want to make sure you are always training your supervisors on those wage and hour issues. Again, if you have multiple locations, if you have multiple levels of management, or if it's really just one foreman that you're working with, make sure that everybody is on the same page. When it comes to wage and hour issues, we're continually seeing problems. The DLSE, that's the Division of Labor Standards Enforcement, that is the labor commissioner. That's who an employee goes and makes a complaint to if they feel that they haven't been paid fairly, if they haven't been paid appropriate overtime, if they haven't been giving their meal rest or meal breaks or their rest breaks. Make sure you're really following along with us. I know we're talking a lot about big laws, but we still see so many issues all the time with wage and hour. So you really need to keep an eye on wage and hour. Make sure your employees are trained on it. We always have great webinars about wage and hour issues. I encourage you to attend one of those when you need them, because that will absolutely help you. When it comes to your handbook, do make sure that you have an up-to-date 2025 handbook. I was just reviewing a handbook from 2023, and they said, I don't think there are too many changes. We did it around 2023, and there were so many changes. So it changes so quickly. Every year, you really do need to update your employee handbook. There's little tweaks. Sometimes there's little ones. Sometimes there's really big ones. If you are an employer that has 5 or more employees, I promise you in the past couple of years, there have been big changes where it comes to CFRA, California Family Rights Act specifically. You need to make sure you have the current and up-to-date language in that. So get a new handbook, get it through us, get it through somebody else. However you get one, I would just really encourage you to have a handbook. But my word of caution is be very careful about downloading any handbooks from an outside service. You need to make sure it's a California compliant handbook. So you don't want to really borrow one from another state or just get a random one off the internet, or even just getting one from a friend who runs a business because their handbook might be wrong. So make sure you're doing it with a trusted partner, whoever that is, if that's CEA or another attorney or resource, great, but just make sure you've got a really good up-to-date handbook. When it comes to those local ordinances, when it comes to minimum wage, keep an eye on that. If you're in the fast food industry, I would keep an eye out around March. If they start talking about another April increase, again, we haven't heard anything about that yet, but we anticipate there will be some changes for that this year. Also, if you're in healthcare industries, keep an eye on those changes because those will be coming this year. And then make sure you've got that labor law poster up there on the wall. For posting, you want to make sure it is in an area that employees have access to. So if it's a break room, if it's your lunch room, if it's where they clock in and out, wherever, that's fantastic. Just make sure they have access to it. We, again, have that in English and Spanish. So whatever your needs are, we can make sure you've got that as well. If you have employees that never come into your office, like never ever come into an office, they're fully remote, you need to provide them with their own poster. So make sure you order one for them. We do have an option on our website for digital posters. So take a look at that if that's something you need for your remote employees. And then of course, stay tuned with our CEA blog. We're always talking about the things going on. Our newsletters have really user-friendly articles where we try to make it as employer-friendly as possible to break down some of these very complicated laws so you know what you need to do to stay compliant. So again, you have access to the wonderful hotline. Call us Monday through Friday, 8 to 5. It is completely free for you because your wonderful county is providing that. But if you feel you need a little bit more help and you need some assistance, we've got a couple of great options for you. You can have an individual membership. That's where you would then have full access to our website. As a hotline member, you don't have access to all of our forms and our toolkits. But if you feel that you do need access, then give us a call. Let us know what we or how we can help you. There's different membership levels. We even have a monthly option, so you can try us out, see what you think. Then the other service I want to let you know about is if you are feeling overwhelmed with HR, if you need a little bit of help, we have something called HR Assist where we can assist you virtually or sometimes even in person. If you need a little help with an HR department, if you have somebody on leave, if you just need an extra set of hands above and beyond the hotline, we're happy to help you with that. So take a look at the website. We've got info, or again, give us a call. And then I want to pop up the hotline number one more time so you know who to call. That's 888-217-6899. And again, we're always happy to help you on the hotline. And then we had a question come in, well, where can I find the sample heat illness prevention plan for outdoor? So we have information on our website for that. Cal OSHA actually has a sample plan as well. So they have done a lot of the work for you and they can help you put that together. If you are a higher risk industry or if you have a lot going on, that's where you might want to consult with an outside source. But we do recommend you can take a look at that. And I know Anna has been feverishly dumping tons of information into the chat box. Thank you, Anna. You are so amazing. So yes, there are links to the wage and hour audit, the labor law poster, workplace violence, the COVID reminders, as well as our blog. So thank you so much for that, Anna. And with that, I will turn it back over to you to wrap up our last couple of slides. And thank you so much, everyone, for joining us today. It's always great to work with you, and we'll talk to you again soon.
Ooh, my goodness, such a flurry. I don't know how you cover all of that information. and we cut into your time too, so you're amazing. So we do have Mary for just another minute. So if you guys have any questions, please pop those into the chat or the Q&A while we still have access to her. But I do want to make sure I keep your attention on the slide. So you can either scan the QR code. I promise it works. I know it's a little blurry, but you can do that. Or once you close out of Zoom here, a browser window will pop up. All you have to do is click opt in, and that will take you to that very brief 5-question survey. It generally takes less than a minute to complete. So we really hope that you share your feedback with us there. If you are joining us for continuing education credits, I have some codes for you. Do you have them on the slide, Mary? There we are. Perfect. And I just dropped them into the chat. So if you are joining us for continuing education, your HRCI code today, 690613, SHRM code 25-DHJJV. As our good friend Eli says, whatever you do, don't forget the dash. And if you are not entirely sure what to do with these codes, but you are looking to get continuing education towards your HR certification, go ahead and shoot us an email, ceainfo@employers.org. Make sure you let us know you're part of Monterey County Hotline, and we'll be more than happy to talk with you and guide you through what to do. So with that, I want to thank Mary for sharing your time and expertise with us. Thank you, Linda, Laura, Corey, the whole Pearl, I think is still on here. The entire team behind the scenes working so hard to bring you resources even beyond today's webinar. So really hope to see you at the next training on March 5th, I believe. I don't know what I actually there. March 5th on customer service. So that is again going to be a free training. So access those QR codes in your handout today. And with that, I want to say thank you so much, and we look forward to seeing you at the next training. Thanks, everyone.